seems to know.
No, you're last, sir.
Okay.
This is an appeal in the matter of Sandhu and Enterprise Rent-A-Car Ltd.
Yes, Mr. Perry.
Good morning, my ladies, my lords, and may it please the court. I should first of all address the issue that we've just been made aware of, that you have two authorities bundles.
Yes.
With one marked from the appellant, one marked from the respondent. We think that they've actually both been provided by my instructing solicitor by the appellant. The only difference between them is that one has the correct sidelining and the other doesn't have all the correct sidelining in it. So the respondents, it's marked respondents version. I believe it's in the grey folder. So
is that the right one?
yes.
Right, thank you. And I see, because the photocopying of this authority was terrible, it was indecipherable. I have to say I'm grateful to Miss Marine because she photocopied the correct report for me, but you've done it anyway.
Yes,
very
as
much
you say, we
Okay.
identified that issue. So
Right. Mr. Perry, before we start, can I make it clear we've read the papers? As a matter of interest, have you and Ms. Stark spoken to each other as to how long each of you is going to take?
I was anticipating being somewhere between half an hour and 40 minutes, but I have to say I haven't spoken to a friend about how long she was going to be.
I have longer than that. I think I'm probably more in the region of an hour and 45 minutes.
All right, let's see how we go. Thank you very much indeed, Mr. Perry. Right.
There are two discrete grounds of appeal, one in relation to the harassment claim and the second in relation to the unfair dismissal claim. If I may, I'll start just with a very brief summary of the facts of the claim. By the time of her dismissal, the appellant was an employee of very long standing. Indeed, she was approaching 19 years service with Enterprise. She was well respected, she was hardworking, and she had achieved significant success in her career. In that context, she'd been reporting directly to the financial controller since the end of 2011. So by the time of her dismissal in May 2018, for over 6 years. There had been discussions in 2016 about a change in reporting line to a more junior manager, but ultimately there was no requirement for that in the short term. The appellant became aware that her father was ill in late 2017.
Just before you move on, you say there was no requirement for that in the short term. Was it made clear to her that that was a temporary arrangement, that she was to be expected to report to the payroll manager in due course?
I believe that is right, my lord, and that it was only a temporary requirement. The appellant became aware that her father was ill in late 2017 and that he had a diagnosis of stage 4 cancer early in 2018. Thereafter, in early 2018, the appellant says that she was subjected to a number of instances of harassment related to her father's illness. You'll have seen those in the main bundle on pages 90 and 91. They are listed in a list of issues at the start of the tribunal's judgment. They include a colleague reporting her to a manager for providing a piece of work 10 minutes late after a hospital visit. That is at 5.3.7 on page 90 in the main bundle. A member of staff being rude to her on her arrival at work late after a hospital visit, which is at 5.3.8 on page 90 in the main bundle. And then when she was offered to leave under a settlement agreement and excluded from the workplace, members of staff justified that by suggesting that she take time off with her father, and that's points 5.3.9 and 5.3.10 on page 91 in the main bundle. In early May 2018, the appellant was invited to a disciplinary hearing to consider allegations of insubordination and capability. At that hearing on the 8th of May, there was a discussion of the appellant's historic reluctance to change her reporting line and the fact that she would need to attend an external course before she would feel able to change her line manager going forward. But shortly after that meeting, the appellant was dismissed by letter on the 15th of May 2018, and the tribunal found that the main reason for that dismissal was the refusal to accept the reporting structure that had been established in 2016. If I turn to the first ground of appeal, which relates to the findings in relation to harassment, the appellant says that the tribunal, despite correctly directing itself as to the law, adopted an impermissibly fragmented approach to the analysis of the harassment claim. The first case that I would refer to is Judge Mummery's decision, Judge Mummery as he then was in the Employment Appeals Tribunal in the case of Qureshi and Victoria University of Manchester, and another from the 2001 Industrial Case Reports at page 863. The first relevant section has been highlighted at the bottom of page 9 in the authorities bundle. It goes over onto the top of page 10. In that section, the judge summarises and then accepts the submissions of Dr. Qureshi's counsel, and that in that case there had been a failure to carry forward primary facts into the critical process of making an overall inference from the totality of those primary facts, and this led to what is described at the very bottom line on page 9 as a fragmented approach that failed to take account of the overall context of the complaints in the case. And that conclusion is repeated in the highlighted passage at the bottom of page 15 in the authorities bundle, G to H, which again stresses that the function of the tribunal is to find the primary facts from which they will be asked to draw inferences, and then for the tribunal to look at the totality of those facts, including the respondent's explanations, in order to see whether it's legitimate to infer that the acts or decisions complained of in the originating application were on racial grounds. It says that the fragmented approach adopted by the tribunal in this case inevitably had the effect of diminishing any eloquence that the cumulative effect of the primary facts might have on the issue of racial grounds. And I accept that, as you can see, for example, from the heading towards the top of page 15 in the authority bundle, that Qureshi is, the decision in Qureshi is explicitly in the context of drawing inferences as to the reason for the treatment, but that language at the bottom of that page as to the eloquence of the cumulative effects of primary facts would apply equally to questions of the effect of alleged incidents of harassment. And in that regard, I agree with His Honour Judge Taylor's decision, or the statement on in the Employment Appeals Tribunal in the current case, which is on page 76 in the main bundle, at paragraph 38, where he says that in a claim of harassment there are a number of respects in which stepping back and looking at matters in the round might result in a different conclusion from a focus on individual issues. He goes on to say there could be circumstances in which unwanted conduct could be split into numerous incidents or treated as one overall incidental conduct, such as a series of comments made over a short period of time. one might take a different approach when considering such comments together as to whether conduct was unwanted, whether it was related to a protected characteristic, and whether it had the purpose or effect of violating dignity, etc. And that, I say, is correct. I've referred in paragraph 3 of my skeleton to the case of Anya and the University of Oxford from the 2001 industrial case reports, starting at page 847. Lord Justice Sedley in the Court of Appeal considered the decision in Qureshi, and this is, apologies, page 32. There aren't too many sections that are that haven't been highlighted in the authorities bundle, but this is one of them. Just to note, really, that from paragraph 9 on page 32, Lord Justice Sedley quotes the decision in Qureshi at length over a number of pages, including the sections that I've taken you to before, and then at on page 36 in the authorities bundle, at paragraph 12. Confirms by reference to counsel for the respondents in Anya that the importance of the Employment Appeals Tribunal's guidance in Qureshi in no way depends on it being a case where the tribunal had effectively sunk under the weight of the factual analysis. Qureshi is of general relevance and applies as much to cases where facts were missed from the analysis as where in Qureshi the court had practically sunk under the weight of them. The third case that I've referred to in my skeleton is the Court of Appeals decision in Rehal and London Borough of Ealing from the 2004 Industrial Relations Law Reports from page 642. This is on page 103 in the authorities bundle. Decision of Lord Justice Keane. Again, apologies, there is a small section that I would refer you to that is unhighlighted at the bottom of paragraph 30 on page 103, where it says that this is about 6 or 7 lines up from the bottom. Nevertheless, what this demonstrates is that it will not always be right for a tribunal to confine such evidence of the wider picture to its consideration of the grounds on which the alleged discriminator acted, i.e. Mummery J's second issue. That wider evidence may also be of value in determining whether the complainant has been less favourably treated than another, not of his or her race, would have been. So again, confirming that the guidance in Qureshi should not be limited simply to questions of discriminatory causation, might be equally relevant to findings as to whether there has been less favourable treatment. Lord Justice King goes on to say at paragraph 31, citing the fragmented approach in Qureshi, that where there are allegations over a substantial period of time, it would be wrong to treat them in isolation from one another. I accept that the reference in that paragraph is to incidents over a substantial period of time. However, I think it's self-evident that that reasoning applies equally, if not more so, to instances that are not far apart. And the key is to look at the widest picture. The final case I want to refer you to in relation to this ground of appeal is not referred to in my skeleton argument, but it's the Employment Appeals Tribunal's judgment in Reed and Bull Information Systems Limited and Stedman, which is on page 20 in the authorities bundle. And the relevant section of it is it's from the 1999 Industrial Law Reports industrial relations law reports from page 299. And you can see on page 20 at the top of the right-hand column, I think it actually starts just at the very bottom of the left-hand column within paragraph 28. It is particularly important in cases of alleged sexual harassment. The fact-finding tribunal should not carve up the case into a series of specific incidents and try and measure the harm or detriment in relation to each. And then there's a reference to a United States Appeal Federal Court decision from the 8th Circuit in USA versus Gale Knapp, which quotes that under the totality of the circumstances analysis, the District Court Fact-Finding Tribunal should not carve the work environment into a series of incidents and then measure the harm occurring in each episode. Instead, the trier of fact must keep in mind that each successive episode has its predecessors, and that the impact of the separate incidents may accumulate. The work environments created may exceed the sum of the individual episodes.
But isn't it relatively clear from the example that's given in paragraph 29 that what Mr. Justice Morrison, who was then president of the AT, had in mind was something rather different from what happened in this case? Because what happened in this case was it's not just one person engaging in a course of conduct, it's several different people, many of whom didn't know about the fact that claimant's father was in hospital.
Yes, Melody, I accept that. And of course, Stedman, as well, is a case in relation to sexual harassment as well, which is obviously not the case here. But I would suggest that there's no reason in principle why, when you're looking at the effect on the individual, why, for example, the fact that there are different individuals involved would not mean that one incident that has a predecessor might have a greater effect than an incident that is genuinely standalone, in that it's an incident that is that is not part of a sequence of events.
Thank you.
If I turn to the application of these principles within the judgment of Employment Judge Quill, as you can see from paragraph 1 of my skeleton argument, we take no issue with the judge's direction to himself on the law, which I've actually quoted from the main bundle. It's on page 117, paragraph 151. I say that is the correct analysis of the effect of Qureshi and the other cases to which I've referred you.
Sorry, can I have that paragraph number again?
Of course, my Liz. Paragraph 151 on page 117 in the main bundle, and it talks about the importance of not carving up the allegations and considering them one by one, and says in the last sentence of that paragraph, this is particularly important when considering whether it would be reasonable to regard the conduct as having the prohibited effect, and whether to draw inferences that the conduct was related to the protected characteristic. And for my purposes, I think the relevance to the prohibited effect is particularly important. And so I accept that this is a case where the judge directed himself correctly on the law, but I say he then went on to apply it incorrectly. The analysis and conclusions start just below where we were on page 117 in the main bundle. The first paragraph that I particularly criticise is over the page on 119, paragraph 172, which is in relation to the extension of a deadline for a colleague, but reporting the claimant, denying the claimant an extension, and then reporting that the work was provided 10 minutes late. The relevant context of that this is probably more for your notes than anything else, is paragraphs 77 and 78 on page 103, which is within the tribunal's findings of fact. That's where it sets out that a report had been presented 10 minutes late after the claimant had been supplying medication to her father, and Mr. Astle reported that to Mr. Young, unlike for a colleague who had been given an extension. If we turn back to page 119 in the main bundle, paragraph 172, the tribunal do not rule out a link to disability. Indeed, tentatively, I think it's fair to say they proceed on the basis that there is some connection between the disability and the incident, but they go on to find that Judge Quill goes on to find that it did not have the required statutory effect, saying we do not think it was reasonable for the conduct to be treated as having the effect of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for her. He goes on to talk about the matter being reported to Mr. Young but no action being taken by him, and the fact that the claimant could have explained the circumstances, and says at the bottom of that page it would be cheapening the meaning of the words in section 26 to treat the factually accurate report of Mr. Astle to Mr. Young as amounting to harassment. And it's clear from the wording of that paragraph that the conclusions, and in particular that last sentence, that the effect of the action is being considered entirely in isolation. There's no hint of putting that into a wider context. It talks about the specifics of it being a factually accurate report.
Well, can I just understand this? This is dealing with specific individuals, yes?
Yes.
What are the context in respect of these individuals? Is that the way you're putting it? This should be viewed in?
I acknowledge that there are different individuals, and
Well, there are, yes.
I cannot say that it's the same individuals. I can't put this too highly. I mean, it is really what it comes down to is the actions of two unconnected individuals who, both of whom, as a matter of fact, the tribunal found were unaware of disability of the claimant's father. But it is the effect of those two actions and the fact that the analysis of that effect, regardless of the fact that it was separate individuals, that is being treated independently of each other, that I say is the error, because one had a precedent and it is actually slightly unclear from the chronology in this case which came before the other, but whichever way round it was, one had a precedent, acted as a precedent for the other, and might have increased the effect of the second incident, regardless of the fact that it's different individuals, regardless of the fact that they are unaware of disability. The second of those instances is paragraph 178 on page 120, where Mr. Hall was rude to the claimant about arriving late from work, having been to the hospital. I think it is relevant to have a look at paragraph 76 on page 103 in the main bundle. The tribunal accepts that the comment was a sarcastic one. Well, it's alleged that it was some sort of sarcastic comment to the claimant, and the tribunal accepts that the remark was made, which I would invite you to include within that it was made sarcastically. We can see that from the fact that the claimant complained about it at the time, and that Ms. Johar was spoken to about it at the time and told that it was inappropriate. again, we can see that in paragraph 76. And then if we turn back to paragraph 177 on page 120, the tribunal again does not rule out a link to disability. They proceed on the basis that there is a connection, albeit a but-for connection. But again, it's found that the action did not have the required statutory effect. I think it's, in light of the questions that you asked already, I think it's fair for me to acknowledge that the third comment that I've included in the skeleton argument that's mentioned in the appeal, which is on paragraph 184 on page 121 of the main bundle. This is a finding that the claimant had been excluded from the premises, and that she was told to go home with her family. There, the finding is actually that that there was no discriminatory motive for those actions. So I accept that there is less to be gained from standing back and considering that allegation together with the other two, because it relates to a different issue. It's not about the effect, it's the conclusion there. Although I say it was reached in isolation, as it was about causation. So I accept that there is less to be gained, and quite possibly not very much at all to be gained from considering that in the context of the other two.
Well, can I just deal with the one we've been dealing with, Miss Johal, if I pronounce her name correctly? One, she isn't aware of the issue of ill health, is she?
No, the tribunal accepts that she was.
And secondly, when the remark has been made, and it's accepted it's been made, she's picked up on it by Mr. Young.
I make the point in paragraph 6 of my skeleton that I say these are borderline decisions. I accept that those words are not used in the judgment, but when you are considering the threshold below which something doesn't have the prescribed effect on an individual to amount to harassment, I say that is inherently quite a low threshold, and one that can be triggered by single comment. So I say it's inherently a borderline decision.
I'm not sure I've understood that. If there's a threshold, doesn't matter where it is, and the tribunal says it's below the threshold, how do we know whether they think it's just below the threshold or a long way below the threshold? I don't see that it logically follows that it must be just below the threshold, which is what I take a borderline decision to mean.
Yes, well, I see the force of that. All the point I'm making, I suppose, is that and I suppose it's more about the level at which the threshold is set rather than how far below the individual act is found to have fallen. But my point is that the standard by which, I mean,
the standard, you'll be much more familiar with this than me, but if I've understood it correctly, if we look at paragraph 144 of the decision on page 116, the relevant section of the Act is set out, and subsection 4 directs the tribunal in deciding whether conduct has the relevant effect, that it must take into account not only B's perception, but the other circumstances of the case, and whether it's reasonable for the conduct to have that effect. So that's the standard that they're actually applying. Is it reasonable? And that's the one that when they say we don't think it's reasonable. And speaking for myself, I would have thought that sort of assessment, reasonableness or not, is a very familiar type of value judgment which is entrusted to the tribunal. I wouldn't myself describe it as necessarily a low one. Reasonableness is reasonableness. I mean, obviously, I entirely accept that one-off remarks can be offensive and harassment within the meaning of the statute, but also the tribunal is well placed, I would have thought, much better placed, to be honest, than we are, to assess, having seen the witnesses, whether it was reasonable for a particular remark to be regarded as having the statutory effect.
Yes. Well, I do see the force in that. I think all I would say is that, as you've referred to in paragraph 144 on page 116, it is necessary to keep in mind the other circumstances in the case when making that decision. And as I say, when you look at the specifics of the decisions and the paragraphs that I've referred to, they're very much focused on the specifics of it not being a factually inaccurate report for the first one, and it being a one-off remark for the second. As I say, I show that is them failing to treat the two together or consider the cumulative effects of how the second might have been impacted by the first. But I do accept it. When I say borderline, I'm referring to the fact that it could, for example, be a one-off comment that would satisfy the requirement. So when you have two of them, but no.
May I ask you a question, please, Mr. Perry?
Yes.
Just going back to paragraph 144, which is a convenient place to look at section 20. One of the elements in harassment is that a person engages in unwanted conduct related to a relevant protected characteristic. What I'd like to ask you, please, is whether the findings of but for causation in two of the instances you rely on are sufficient to mean that the conduct is related to a protected characteristic.
Well, you'll be aware that it's not a question of the reason why a comment is made. So the fact that the individuals may have been unaware of the disability of the appellant's father would not prevent their conduct later on being related to it. I say the fact that these two instances arose as a result of the claimant being either unable to work or arriving late from work as a result of visiting a disabled relative is enough for it to be related to. I mean, it's a very...
Have you got any authority that supports that analysis, please?
I'm afraid I don't to hand, on the basis that I'd understood that the tribunal had accepted that point, and that was not
Well, not
basis
sure,
on which
not sure that's right. I mean, what the tribunal says is the remark was unwanted conduct. In a but-for sense, there was some connection. But is that it? All I'm asking for is some authority that says that a but-for connection is enough. Because in 178, we go on to say, even assuming for the sake of discussion that this was sufficient to justify a decision that the unwanted conduct was related to blah blah blah. So what I'm trying to explore is whether that assumption would have been correct as a matter of law.
Well, it certainly wouldn't have been for either direct discrimination or discrimination arising from disability where there is a requirement for for a conscious or subconscious motivation for an individual.
That tells us that harassment is related to disability, even though the person doesn't know about the disability of the person concerned, or in this case, the disability of the father. I'd like to know.
I mean, I am aware of an authority. I'm afraid I believe it's Thomas and Sanderson Blinds, but I don't have the reference where an individual who it was known was not homosexual was bullied by reference to a suggestion that they were homosexual. In those circumstances, the fact that the harasser actively knew the individual did not have the protected characteristic, did not prevent that amounting to harassment. So, I mean, it's a slightly different issue, but I have to say I'm not aware on whether the tribunal is right or wrong on the fact that but-for causation would be sufficient.
All right, that's helpful. Thank you.
It's quite an interesting point, isn't it? Because as my lady points out, the tribunal doesn't actually conclude that it was related to. They address the point both at 178 and with the earlier remark, or as you said, we don't know which remark is earlier, but the one they deal with earlier at 172 on the assumption that that might be enough, and the reason they dismiss the complaint is because it doesn't have the requisite effect. But if one just reads the statutory words at 144, what is prohibited is unwanted conduct related to a protected characteristic. In both cases, Mr. Astle reporting that she handed in the folder late and Miss Yohal saying good afternoon to her when she turns up late. If one accepts, which I think the tribunal did accept, that neither of them knew about her father's illness, it's quite a stretched meaning of the words that conduct was related to disability. One can see that the effect might be in the appellant to relate it to her. You know, the reason I'm late is because my father's ill, and that's, I find that offensive. But when one looks at the conduct, which is to say good afternoon to somebody, which is obviously sarcastic or rude, unless it's just funny, it doesn't have any obvious connection with a disability. Clearly not the appellant's disability, because she's not disabled, or her father's, because the person who says it knows nothing about it. I think there is a real doubt as to whether it's related to or not.
I have to accept that's a valid point, and it may be that if the lordships and the lady are with me on the effect point, that would need to be clarified by the tribunal. You'd have to make a clearer finding on that, because that's not the basis on which that claim is dismissed.
No, I
it
understand
sort
that.
of proceeds on the basis that there is, but I acknowledge that it says for argument's sake, for example, and I do see the argument there.
Sorry, I'm so sorry. What do you mean, Mr. Perry, by a clearer finding?
Well, as to whether the conduct was related to, rather than saying, well, in a but-for sense, there was connection between the claimant's father's disability, whether that equates to the same thing as it was related to.
Well, all right. Thank you.
All right, Mr. Perry, where now?
So if I just to conclude on this, I say that essentially what's going on here is that the claimant arrives late from work from visiting her father in hospital. She's subjected to a sarcastic comment about timecaping, and that may well have contributed to her reaction to then being prejudiced later that month by not being allowed an extension when her colleague wasn't. In the circumstances where the tribunal didn't stand back and look at the effect of those two instances together, it might have come to a different conclusion on the required effect had it done so. And I acknowledge, as Judge Taylor referred to in the AT, it might not have added much. This is paragraph 43 on page 77 of the main bundle, when he says we do it is not surprising that the Employment Tribunal said little about an overall assessment here, because there was little more on the facts that an overall assessment could achieve. I acknowledge that it is a limited amount possibly that an overall assessment could achieve, but it might be enough to make one of those instances amount to have the required effect.
You say the way you just put it was as if the sarcastic comment came before Mr. Astor's
We don't know
report,
which.
but I think you accept it. It's not clear which happened first.
It's not, and I believe we have a date for one of them on the 27th of March, and the other is said to be in the last week of March. So it's not quite clear which came before the other, but either way, the point I would say is valid, that it could be a cumulative effect.
So the point only goes to the second one, because the first one can't be affected by something.
Absolutely, but we don't
Whichever
know.
one is second, you say the effect could have been magnified
Yes, by the
by
fact, yeah.
of the previous one. I see.
And so can I get this absolutely clear? That is your refined point on your
Yes.
first ground.
I think that's as highly as I
Well,
can.
no,
proceed.
let's be realistic. Thank you very much indeed.
If I turn to the second ground of appeal, apologies that a very inadequate copy of it was provided in at least one of the authorities' bundles, but the leading authority on the adequacy for reasons for judicial decisions is English and Emery, Reinbold and Strick Limited.
I mean, sorry to interrupt,
Sorry.
isn't it really Meek in this context? I mean, Meek is what's always cited when there are reasons, challenges to decisions of employment tribunals, and this case is all about civil claims. So, I mean, it may be that you can read across from English and Emery, Reinbold, but generally speaking, in my experience, it's Meek that's referred to, and those authorities in the employment sphere in which Meek has been commented on.
Yes. Certainly, my idea as to the structure of employment tribunal decisions, but the reason I've referred to English is that I think in terms of the principles and the fundamental principle about what a judgment needs to address, I think it's wider than just in the point that applies just to the employment tribunal. If I may refer you to page 49 in the authorities bundle. Again, apologies, this is another the unhighlighted sections.
I had a more fundamental point on this authorities bundle. It's why are there so many, and it's directed to both of you.
I think the reason why there are a number that haven't or aren't referred to is that there are some that were relied on in the in the Employment Appeals Tribunal, which are essentially simply applying the principles from Qureshi that I've referred to. So there are a number of Employment Appeals Tribunal decisions in there that probably shouldn't be, and I apologise for that.
If I could also respond, since you're directing to both of us, I believed until about 20 minutes ago that we were about to have a much more complicated legal debate than I think we're going to have today, and I had lots of authorities that were ready for that debate. But since we're not going to have it, we won't need to go to those authorities.
I see. Thank you.
The section on page 49 that I was chosen to refer you to is 4 lines down from the top, where it says that the extent of the duty. So this is Lord Phillips quoting Lord Justice Henry in Flannery's case. He says the extent of the duty, or rather the reach of what is required to fulfill it, depends on the subject matter. Where there's a straightforward factual dispute whose resolution depends simply on which witness is telling the truth about events which he claims to recall, it's likely to be enough for the judge, having no doubt summarised the evidence, to indicate simply that he believes X rather than Y. Indeed, there may be nothing else to say. but where the dispute involves something in the nature of an intellectual exchange with reasons and analysis advanced on either side, the judge must enter into the issues canvassed before him and explain why he prefers one case over the other. And that is a point that is made rather more pithily on page 51, paragraph 16, that justice will not be done if it's not apparent to the parties why one has won and the other has lost. That point is expanded on a little bit more again over on page 52 in the authorities bundle at paragraph 19, where it says that if the appellate process is to work satisfactorily, the judgment must enable the appellate court to understand why the judge reached his decision. It doesn't mean that every factor which weighed within the with the judge in his appraisal of the evidence has to be identified and explained, but the issues, the resolution of which were vital to the judge's conclusion, should be identified, and the manner in which he resolved them explained. And it's that point as to the vital elements of the decision-making process being apparent from the judgment that I rely on.
I'm so sorry to interrupt you again. This is my fault entirely. I didn't catch the first paragraph reference.
Of course, maybe it's
'Cause I-
page 49.
Yep.
It's within paragraph 6 at the top of that page, and that is, as I say, it's quoting the decision.
Yes, I see.
And it's from little subparagraph 3 within that.
Right. Thank you very much.
And I recognise that the decision has to be read as a whole, and that any appellate authority shouldn't be overly pernickety, which is the decision of Lord Justice Popplewell in DPP Law Limited and Greenberg, which is towards the back of the authorities bundle on page 417. That's from the 2021 Industrial Relations Law Review from page 1016, and in our authorities bundle it's 417 at paragraph 57. Quite a lengthy section, but I'm sure it's one with which you're quite familiar. And there's a quite an extensive quotation from Brent and Fuller in that paragraph. And it, as I say, it recognises that the decision must be read fairly and as a whole. Subparagraph 2, the bottom of the left-hand column, the tribunal is not required to identify all the evidence relied on. And
There's a reference to Meek in subparagraph 2.
Yes, findings and reasoning, just simple, clear, and concise as possible to be encouraged. It goes on to refer to the fact that just because something is out of sight in the decision of the language is not to be presumed that it's to be non-existent, certainly in relation to findings of fact. So I acknowledge that there is that latitude given to judges, but there is also the counter argument to that, which we see on page 41 in the authorities bundle. On the case of Dr. Anya versus the University of Oxford, paragraph 26. Apologies, this is, I believe, the last unhighlighted section. Which acknowledges that the courts have repeatedly told appellants that it's not acceptable to comb through a set of reasons for hints of error and fragments of mistake and try and assemble those into a case for oversetting the decision. no more is it acceptable to comb through a patently deficient decision for signs of the missing elements and try to amplify those by argument into an adequate set of reasons. So it's, I believe, it's on Judge Taylor referred to it as yin and yang provisions in relation to the sufficiency of reasons. If I turn to how I apply those principles to the judgment in this case.
Well, are you going to deal with the Employment Tribunal judgment?
Yes.
Good.
It's page 90, where the list of issues is set out. I've referred to this at the start in relation to the disability discrimination and harassment, but you can see at the above that section towards the top of page 90.
I'm so sorry, could you just give me a chance to catch up?
Of course, so apologies, ma'am.
I'm being very slow. Sorry, did you say the list of issues is at page 90 in the bundle?
Yeah, so it's within the decision of the tribunal,
Oh, I
which
see.
starts on page 88.
Right.
And at the bottom of page 89, there's a section in relation to unfair dismissal. And there are a number of factors listed under paragraph 5.2, which are the claimant's complaints. And over the page on page 90, they're not bullet pointed, but I think they are effectively bullet points. The last and the third from last, second from last, the dismissal was outside the band of reasonable responses due to a failure to follow incremental disciplinary sanctions and due to no consideration of sanctions less than dismissal. That's the third bullet point up. So it's clear that those two matters were in issue as to the fairness of the dismissal, but they are then missing from the analysis of the fairness at page 186, paragraph 186 on page 121. And
are they two separate points, really, or is it all the same point?
I think there is a slight distinction between them, in that one relates to the warnings that are provided to an individual, and the other relates to whether there was even consideration of a sanction other than dismissal. I think there is a slight distinction, although I acknowledge that they are closely linked, because obviously the sanction would be a warning if it were not dismissal in some form. So I do acknowledge that there is a link between them. A number of matters as to the fairness, or a number of the claimant's complaints about the fairness of the decision to dismiss are addressed here in this section from paragraph 186 onwards. Paragraph 202 talks about the claimant being given the opportunity to improve in relation to performance issues, and that is obviously distinct to an extent from a warning that she would be dismissed for failing to report to a different individual. But that was raised in the list of issues at the start, and it's addressed in the judgment. The question of the procedure, in particular the appeal procedure, being predetermined due to the protected conversation, is addressed at paragraph 203 on page 123. And further up on that page at paragraph 200, the reasonableness or otherwise of refusing to postpone the hearing on the 8th of May is addressed. But the two matters about warnings and about consideration of sanctions other than dismissal are not dealt with, and they are not minor matters. The extent to which an employee is warned that they may be dismissed and the extent of considerations of sanctions other than dismissal, I say, are central to determination of the fairness of the dismissal.
I do apologise. Carry on, please.
And I say that is, looking back at the language from English, that is a matter that it was vital for the tribunal to decide on and set out its reasons on, so that the parties are able to understand the decision on unfair dismissal. Absent a clear explanation of the court's findings on those points and the importance of them, the claimant simply, or the appellant simply does not know why those alleged failures did not render the dismissal unfair.
To be fair to the Employment Tribunal, they do expressly deal with their worry about the fact that the claimant had not been formally warned before the 3rd of May letter.
Yes, and that are you referring to paragraph 192? Yes, and His Honour Judge Taylor makes exactly that point in paragraph 48 of the Employment Appeals Tribunal's decision, which is on page 80, where he says in paragraph 192, when dealing primarily with the issue of whether the claimant had been given sufficient notice of the disciplinary hearing, the tribunal recorded, and then he goes on to quote paragraph 192, and he then refers to paragraph 193 in paragraph 49.
Well, 193 is also important, isn't it?
Yes, in that
Significance of the failure to warn her beforehand.
yes, but I would suggest that Judge Taylor read too much into those two
It doesn't matter
paragraphs.
what Judge Taylor read into it.
Well, sorry, I would invite you not to reach the same conclusion in relation to those paragraphs, because all paragraphs 192 and 193 show is that there was no evidence of a warning before the 3rd of May,
Yeah.
but that the claimant then did not request a postponement of the hearing because of that. Neither of those paragraphs, nor
That's not all that they say in 193. They do say that, and they actually conclude that it was unreasonable not to offer her a postponement, but it didn't, in the end, make any difference. But they also say in 193, they refer to the prominence of this issue in the dismissal reasons, but then they go on to say, but she didn't say, oh, well, that's unfair because if only you'd warned me, I would have changed my mind. She goes on to say, that's not a surprise, but I really shouldn't have to report to Mr. Astle. In other words, she's engaging with the point as to whether she is going to report to Mr. Astle or not, which is a response to the substance of it rather than just a postponement of the hearing. Sorry, I'm slightly taking you out of your course there, but it was just you said that they dealt with the postponement question. That's not all they deal with in 193.
But I would say that neither of those paragraphs explains why those matters address whether there was a consideration of sanctions less than dismissal, or explains why the dismissal was fair. I mean, I acknowledge that from a sort of procedural point of view, I think it's primarily a comment on the procedure and the postponement or lack of postponement. I acknowledge that the claimant was able to engage with that matter at the hearing.
It's not just that she was able to engage with the matter at the hearing, she engaged with it in a particular way. Isn't that what's significant?
Well, it might have been different if her reaction had been, I didn't realise this was such a serious point. Had you warned me, I would have amended my stance. But it looks from 193 as if that's not what the tribunal thought that she had done. She said, well, there's no reason why I should report to Mr. Astle.
Yeah, I think there are a number of points to raise in response to that. The first is that the claimant had been operating in her existing reporting structure for over 6 years without sanction, and which I think makes it somewhat more understandable why there was a reluctance on her part.
Well, can I just pause there? Because I can't get this clear at the moment. There seems to have been a somewhat informal arrangement because she wasn't happy about reporting to Mr. Astill, and so the reporting to Mr. Young continued. Is that fair?
I think that is, yes. Right.
If one picks it up at paragraph 73, there is the issue as to whether it was asserted to her prior to this meeting that the reporting arrangement had to come to an end. And one can pick it up. Taylor and Young each asserted that the reporting arrangement for the claim to temporarily continue reporting to Mr. Young had been correctly approved in the past. I don't think there's any issue about that. It was suggested that this was a temporary arrangement and that from 1 April she'd be reporting to Mr. Astill. We have not seen any contemporaneous written document which specify the date was given to the claimant or when, and that is picked up later in the judgment, where they make exactly the same point, namely the lack of contemporaneous documents supporting that position. So where are we? That was 73.
73 and
And
next one.
I've lost it. Wait a minute, I've got it. Give me a sec. It's 86.
Do you swear?
So
Sorry,
what
Milena,
is-
I'm not sure I quite understand the question at the end of
What
that.
I don't, and this is my fault, and I hope I'm not taking you off train. By the time of this meeting, the primary purpose appears to be unwillingness to report to the approved person. All right? And the point that was being taken by my lord and my lady was she was engaging with that issue at the meeting. What I was seeking to find out was before the meeting, was that actually put to her that the arrangement had come to an end and she had to report to someone else, because it's just not clear at the end of 73.
Yes, I think it is unclear. I'm sorry if that's an unsatisfactory answer, but my understanding is that the sorry, I'll just bear with me a second. Yes, I mean, I'm not sure we go beyond what's at 192, that there's shown no evidence of being formally warned prior to the 3rd of May about not reporting. So
I think as someone who was at the factual hearing, it might help to fill in the black hole we have here to say that the key part of the factual narrative that the tribunal can't fill in is the without prejudice discussion at the end of March. So nobody knows exactly what was said at the without prejudice discussion about reporting lines, but that's the bit of the timeline that we can't fill
Well,
in.
you say that, but in fact what they do is itemise certain matters that were dealt with at that meeting, and signally absent from it is the reporting line issue. So it begs the question whether it was discussed or not. So with respect, I don't think that takes it a great deal further. All right, Mr. Perry, let's carry on.
I mean, the only other point to mention is, in this context, is paragraph 110, where there's a little bit more. This is on page 109 in the main bundle, where there's a little bit more on. This is in the context of the dismissal letter, but referring to the meeting on the 8th of May. referring to the fact that the claimant had said she could not do this straight away, as she could first need to attend an external course to help her come to terms with this. And refers to the fact that course had been started but not completed. So I don't think it.
Previous occasions, do we know when those were? The two previous occasions?
I'm afraid I don't.
Because that rather suggests that the idea of going on the course, this wasn't the first time that issue was raised. Because she'd started but not completed this external course on two previous occasions, unable to recall the name of the court. So it's a bit mystifying, isn't it? You're not able to help with that.
I'm afraid I'm not. So I don't know whether my own friend can answer that when she addresses you later.
When it says but been able to complete this external course, should we read that as being unable?
Yes, it's
to complete?
Either way, I say it's not quite as simple as the claimant flatly refusing at that stage. Clearly there was some discussion about what would need to happen before she could report to Mr. Astle. So I don't think, and one of the points that His Honour Judge Taylor makes in paragraph 51 of the EAT decision on page 80 over onto page 81 says that warnings can be an important element of fairness where an employee is challenged about their actions at a formal hearing and agrees to change and abide by the policies. It can be argued that dismissal would be inappropriate and the employee should receive a warning not to act in the same way in the future. And if an employee is told that they must act differently in the future but is not prepared to do so, warning is less likely to achieve effective resolution of the problem. I don't think that, although I don't necessarily disagree with that, I don't think that strictly speaking applies to the claimant's reaction to, or the appellant's reaction to the situation, in that there was a discussion about what she would need to do in order to get to a position where she could report to Mr. Astle.
I'm so sorry, my fault again, Mr. Perry. I missed the reference that you gave to that passage that you just read out.
I'm very sorry.
No, it's not your fault.
It's page 80 and 81 in the main bundle, paragraph 51.
Paragraph 51. Thank you.
And I say, putting it simply, that the appellant, having previously indicated dissatisfaction with a decision as to who she should report to, and the fact that she continued to express some consternation about that, or that suggested that steps would need to be taken before she would be able to report to Mr. Astle, doesn't mean that she should be denied the protection of formal warnings in accordance with a disciplinary policy before deciding to dismiss. And in light of that sort of slightly ambiguous response that she's given, I don't think it's clear why that would lead to dismissal without consideration of sanctions less than dismissal, and we simply don't know what the tribunal's findings were on whether there were considerations of sanctions less than dismissal, and why those considerations or lack of them didn't make the dismissal unfair. So for those reasons, I would invite you to find that the tribunal's judgment on the unfair dismissal is unsafe and insufficiently reasoned. I should mention briefly that I've acknowledged that my skeleton argument refers to the ACAS code applying and the decision of Mr. Justice Keith in the Employment Appeals Tribunal in a case called London St Edmund's School, Canterbury. But there is I need to acknowledge that there is a contradictory decision of the Employment Appeals Tribunal on the applicability of the ACAS code, and really I was only referring to that in the context of a general suggestion that you would normally expect there to be warnings before dismissal. So I wouldn't want my ladies and my lord to be confused by that point, and I will not be taking that point further as to the applicability of the ACAS code. I've set out my observations on the reasons why I would suggest remittal to a fresh tribunal if you're with me on any part of the appeal, in particular paragraph 23, little 3 of my skeleton argument sets out the reasons why we say it should go back to a fresh panel. Unless I can assist your ladyships or your lordship further, those are the submissions for the appellant.
Thank you for.
Oh, sorry.
Go ahead.
I'm so sorry. I've just got one question, please, if I may. Can we just, if we go back to the summary of the issues in paragraph 5 of the ET's decision, right at the bottom of page 89 of the document. So this is listing the claimant's complaint. The last one is failure by the employer to warn the claimant should be dismissed if her performance not improved. Does that complaint include a complaint about reporting lines, or is it just related to the fact that she'd had all these negative performance assessments and she'd received a warning about her performance, and that was part of the reason for dismissal, which she hadn't improved?
I understood that to be just in relation to the performance issue.
That's what
Yes, and that is addressed in the judgment. That point, I think it's paragraph 202. There is a finding that she had been given opportunity to.
But it then follows, does it, that one of the express issues that they were supposed to be considering was not failure to give a warning that she'd be dismissed if she didn't accept the reporting line.
No, to the extent that that's not covered in the last point about dismissal being outside the band of reasonable responses because of the failure to follow incremental disciplinary sanctions. So that I think is where the lack of warnings comes in.
Right. I see.
Can I ask you on that point? The very last, as you've just read, the very last issue on the list of issues is dismissal was outside the band of reasonable responses. And then the suggestion that there was a failure to follow incremental disciplinary sanctions. And the question whether the dismissal was outside the band of reasonable responses is dealt with by the tribunal at 201. The actual dismissal decision itself was not outside the band of reasonable responses. Is it not implicit in that the tribunal has considered whether some lesser sanction really ought to have been applied first, whether there should be an incremental disciplinary sanction, and has rejected it? If you say dismissal is a reasonable response, or within the range of reasonable responses, you are rejecting the suggestion that the only reasonable response is a lesser disciplinary sanction, aren't you?
I think that is falling into the error in Anya of looking for parts of a decision that aren't there and trying to infer
Yes.
them. And as I say, the reason why I think English is so important is that there are certain points that you could say that they could be wrapped up in that way, but these issues about what consideration at all was given to sanctions is so vital, it's so essential to that decision, that I think it should have been set out explicitly in some way, rather than just. I think it's too important to infer it into just the fact that the decision was found to be within the band of reasonable responses, because their fundamental criticism saying these are the reasons why it's outside, and there's simply no reasoned or rational explanation for why the tribunal disagrees with that on that point. There are a number of other points around, as I say, the suggestion that things were predetermined, that there was a failure to postpone, that there was a lack of opportunity to improve performance. Those points are especially dealt with, but these points, which we say are the most important ones on the unfair dismissal, are not.
Thank you. That's very helpful.
Thank you very much indeed, Mr. Perry. We'll rise for a couple of minutes.
Court rise and table.
Make a more complicated point than you made. I've been deleting my submissions.
sorry.
It's okay.
If it's about this question of whether there's some kind of supplementary analysis on top, I was thinking about that last night as to whether it is a different point, because well, I think it's the sequential point. Right?
Yeah.
As in one has a predecessor and the other, so
Yeah.
you have to be.
Yeah.
That is another
Well, and there
layer,
is
because
a
you could find
suggestion.
initially yes it's enough, and then you don't have to go to the next layer.
Because I think the best case on it, if someone was going to make that submission, is Fearon, and I think the analysis is wrong. But in Fearon, he says it could be possible, even if you've correctly lost in a Qureshi compliant way on everything in the chain. That's the one where regimes pleaded.
There's some kind of practice, and
Yeah,
to keep,
but even
which
then,
is not the case for us.
but even then, like imagining you can persuade them that it doesn't have to be pleaded, that the case law says it doesn't have to be pleaded. What I struggle with is his basic idea in Fearon that you could ever lose on everything in the chain, having analysed it properly in a Qureshi compliant way, and somehow win on the whole chain.
Court rise and table.
Right, thank you.
My ladies, my lord, I will take the two grounds in turn. The first ground alleges, as we know, an error of law in respect of the harassment findings, and the nature of that error of law, and my learned friend's reading of the case has only become clear to me today. As I had always understood the appellant's position, partly from our arguments below and partly as I've asked him for clarification, I'd always thought it was being said that, applying Reed and Stedman in particular, when the tribunal has to consider a pleaded list of allegations in a harassment or discrimination claim, it also has to consider an extra unspoken issue that's implicit within the list of issues, that is whether, even if none of the pleaded allegations amount to harassment individually, despite having been analysed in their full context in a Qureshi compliant way, they nonetheless amount to harassment when taken together. So that would effectively import a third function after the first two functions in Qureshi.
But he's not taking it.
But he's not taking that point,
It's
so I can
a really
make.
narrow point that's been clarified this morning. We're
Yes.
grateful for the clarification.
I'm very grateful for that clarification, and as a result, I think I can make much shorter submissions for you today. So what's really being taken today is just that when determining each allegation under function 2 in Qureshi, inferences must be drawn from all the others in respect of not only the reason for the conduct, that's Qureshi itself, but also whether the conduct reached a sufficiently serious threshold to constitute harassment, that's Reed and Stedman. And there's nothing between us on that. So that being the case, I just want to take you to a few of the cases that focus on what is required for the tribunal to demonstrate its compliance, what kind of signposting has to be done, to show you actually how very little signposting has to be done in cases where the EAT is comfortable that the factual analysis and the inferential analysis is on its face sound. In those cases, there can be hardly a sign of Qureshi analysis on the face of the judgment, and the EAT has no concerns. So that's the only analysis I'll take you to in the case. The first case to look
Sorry,
at.
just
Yes.
before we look at the cases,
Yes.
if I understood it correctly, so where we ended up with Mr. Perry's very helpful explanation this morning was that whichever was the second of the two instances
Yes.
where there were consequences of her being late,
Mm-hmm.
let's assume it's the one where Mr. Astle reported her,
Yeah.
although we don't actually know which it is. The effect of that could be magnified because of whatever the first one was.
In principle.
Yes. Now, as a matter of principle, do I understand you? You don't dispute that?
No.
Thank you.
So why have you got to go to all these authorities?
So what I want to show you in these authorities, and it won't take me long now.
Because in fairness to Mr. Perry, he really did clarify it this morning. One of the things the court is grateful for is the identification and narrowness of the topic, and one would hope that is how the response will be directed.
Absolutely, I've got to be a third of my submissions as a result. All I want to show you is that what is interesting about, I think it's 5 of these cases, is that the tribunal only really finds, the EAT only really finds breaches of Qureshi when it's actually concerned about the internal logic, the substantive logic of the reasoning of the tribunal. It isn't looking for kind of tick box Qureshi analysis and signposting that Qureshi has been complied with. It's only worried if there's real substantive reason to think that something has been missed on the facts. And that's important when we look at our judgment, so that you can be reassured that unless you're actually worried about this judgment substantively, we don't need to be concerned about the fact that you don't necessarily in every paragraph see the court stepping back, see the tribunal stepping back and saying, have I considered all the other facts? Have I considered every previous incident to see if it contributed to the threshold in an express way? That's the only thing I'm taking you to the case law for. Are you happy for me to proceed?
You proceed as you wish.
Thank you. So this point is made very shortly in Anya, and it's just a dictum from Lord Justice Sedley at page 35 of the authorities bundle, at paragraph 10. And he really just introduces the point that I'm about to show you playing out in the case law. He says in the final sentence of that paragraph, it may be that, as in King's case and other cases demonstrate, the breakdown of issues need not always be as elaborate as was necessary in Qureshi. So I'm going to show you that play out in 5 cases in the EAT. 3 cases in which the EAT has no substantive concerns about the analysis and therefore no Qureshi complaints. And those are Sahota, Fraser and Leicester and Coley. And 2 cases in which the EAT finds a failure to comply with Qureshi, but we can actually see more substantive concerns underlying it, and those are X and Y and Talbot and Costain. So first, Sahota and the Home Office in 2009. So in Sahota, the claimant challenged 10 different acts of less favourable treatment and harassment because she was undergoing IVF. The tribunal found against her for a range of jurisdictional reasons, but also on the merits. You needn't turn it up, but that's page...
It's tab 14.
Yes.
Page.
So the findings against her for jurisdictional reasons, but also on the merits, is page 212 at paragraph 16. And you can see at 17b that one of her complaints was that the tribunal had adopted a fragmented approach and failed to consider the effect of the alleged incidents viewed as a whole, contrary to Qureshi. So it's like this case in that it involves a series of acts, and there's a complaint about looking at those acts too much in isolation. And that ground of appeal failed. You can see that on page 223 at paragraph 49. And ultimately, Peace Clerk QC found that the tribunal had not erred because it had considered, as it was obliged to, each allegation of discrimination separately, but it plainly had the whole sequence of events in mind. So that's the function 2 analysis in Qureshi. But what is worth looking at is how little was actually required to persuade the EAT that the tribunal had had the whole sequence of events in mind. And we can see an example of the tribunal's reasoning in the quotation at page 220 at paragraph 39. I'll give you a moment to look at that. So we can see that unlike Employment Judge Quill's judgment in this claim, which we will turn to shortly, the tribunal in Sahota was not going out of its way to use language evoking Qureshi, such as there are no facts that could lead to a finding or an inference of discrimination or harassment. It was simply making positive reasons, positive findings for what the specific act was and what the reasons for it were. And that was all it did. There's no express wording at all to show compliance with the second function of Qureshi. And you can see the EAT's analysis accepting that approach at the bottom of the page at paragraph 40. So the first decision was made on the basis of certain advice. That finding is fatal to any discrimination claim. Despite this relatively narrow finding, the AT nonetheless reached the conclusion that we've seen at paragraph 49, that the AT had the full sequence of events in mind. The second case we have in this category is Fraser and Leicester University. Another one like Sahota, where the claimant had pleaded a series of discriminatory acts, had been unsuccessful below, and in her appeal had made a Qureshi complaint. At page 315 to 6 of the authorities bundle, you can see her claims below. At paragraph 41 at the bottom of the page. And her ground of appeal, as relevant to this appeal, is at page 325 at paragraph 57.2. There it said she didn't accept that the Employment Tribunal had stood back and looked at the picture as a whole, even though it said it had, and she cites Rihal, I think. Perhaps not there. The EAT then summarises the principles from the case law. You can look at that, but that's at page 330 at paragraph 74. And the tribunal summarised its conclusions on this at page 335 at paragraph 89. So finding against the claimant, it said that the tribunal had applied the correct test merely by asking whether the claimant had established facts from which it could conclude that the reason for the treatment was discriminatory. And it is apparent that the tribunal also looked to see what inferences it might draw from the primary facts found. So per Anya, per Qureshi, nothing more was required. If we take a closer look at the judgment, we can see the EAT seems to have accepted an approach that's actually very similar to the one adopted by Employment Judge Quill throughout most of the judgment subject to appeal in this case. So we can see an example of the tribunal's analysis at page 336 at paragraph 91. So the claimant complains that the tribunal had found that the second respondent was reluctant to praise her, and yet had still found that there were no facts from which it could conclude that he would have expressed his views differently if she'd been white. And the claimant argued the tribunal should have drawn inferences from the finding of reluctance to praise her. And then at paragraph 92 over the page, Her Honour Judge Eadie, as she then was, rejected this on the basis that the second respondent's attitude was dealt with in its primary findings of facts. So the relevant material had gone in the factual narrative at the beginning. That was enough. And that analysis was taken to have underpinned its conclusions in respect of the other grounds. And then she found, looking at it on its merits, that the tribunal's factual analysis on the specific allegation couldn't be faulted. So breaking that down, it's sufficient to deal with the primary facts in the facts section. That will be taken to underpin the rest of the analysis. And then it seems that analysis of specific allegations just needs to be sound in and of itself and needs to be not perverse. And it certainly seems to be sufficient if you're using language like no facts from which it could conclude, which is exactly the kind of language we see deployed in the judgment subject to appeal. So that's the second. The third and final one in this category is Coley. Which is tab 26. That appeal concerned direct race discrimination. The claimant had pleaded 4 factual allegations, which you can see at page 439 to 40 at paragraph 22. Is that right? Sorry, 438 to 439 at paragraph 22. The relevant ground of appeal is at page 444 at paragraph 41. That was that there had been a failure to step back to consider the pattern of discriminatory behaviour which the claimant alleged contrary to Qureshi and Anya. Mr. Justice Linden in the AT didn't accept that the tribunal had erred. And again, it's useful to see just how little was required by way of showing compliance with Qureshi. So at page 456 at paragraph 91, he found that the tribunal had complied with its Qureshi duty in that it made its findings of fact as one chronological narrative, and it then reached its conclusions on all of the job role complaints together under one heading. It considered the performance appraisal under a different heading, but then it also considered whether the job role issues affected the appraisal score and vice versa, and then it stepped back and expressed an overall view. And at paragraph 92, he concluded, we're quite satisfied that the ET had the whole picture in mind. And again, there are lots of parallels there to the judgment under appeal today. As we'll see, that judgment made the findings of fact as one chronological narrative. It dealt with all the discrimination and harassment claims grouped together. The only difference is that in Coley, there was this kind of stepping back sentence in the conclusion of the judgment. And we can see it at page 441 at paragraph 26. That's the conclusory judgment, that's the paragraph that's being spoken about here. But we know that it's not necessary to have this kind of paragraph in there to show compliance with Qureshi, because there wasn't one in Sahota, there wasn't one in Fraser. And indeed, there's no particular reason why there should be, because if each time the tribunal assesses the next allegation in the chain, it has in fact had in mind all the contextual evidence, there would be no particular need to have a catch-all analysis at the end, where it loops back to say, and our decision is not changed by considering all the contextual facts. That should have been inherent to its analysis all along. So those are the 3 cases showing just how light the requirement should be. I will go quickly to the 2 cases that show you the kind of facts that would make the EAT want to intervene. So the first authority we have is X and Y, 2013. So this was another case in which the claimant had pleaded a series of discriminatory acts. That's tab 17. I'm working electronically, so I don't have the numbers for the tabs. This was another case in which the claimant had pleaded a series of discriminatory acts in that case race and sex discrimination, been unsuccessful and appealed running a Qureshi ground. You can see her ground of appeal at page 272 at paragraph 34. Articulated as the tribunal failed, having gone through the individual complaints, to stand back as it should have done. And we can see immediately that the appeal is, yes. The EAT sets out extracts from Qureshi and Yerial, and it applies that reasoning at the top of page 282. You needn't go to that. It draws its, let me find this, sorry. Yes, it draws its conclusions at the top of 282, which is useful to go to, at paragraph 60.
It might just be helpful, because it just caught my eye. Sorry to interrupt, Ms.
Yes.
Paragraph 36. In view of the large number of what were serious breaches of duty, there was a need for full and careful explanation as to why the cumulative effect of those breaches, open square brackets, I refer to them as breaches because they found to be breaches of the implied duty of trust and confidence, did not give a flavour of discrimination generally. So it rather looks as though on the facts it was a different case from this case.
Exactly, very much so. And then we can see in paragraph 60 a list of all of the different problems, both with the seriousness of the breaches in the case and also the seriousness of the problems of the tribunal's analysis. So there had been a significant number of contractual breaches which the EAT said called for explanation. The EAT said, simply finding poor management is not sufficient, as that might be a symptom of discriminatory conduct. The tribunal didn't take into account the post-termination facts. It didn't have regard to the fact that Ms. Ball was not the only person who might have been responsible for the conduct. So all in all, paragraph 61, the evidence was sufficient to shift the burden of proof, and that was what called for explanation. So that's the kind of underlying substantive error that motivates the EAT to say there's been a failure to stand back and look. What's actually going on here is there's been a failure to take into account other contexts which has led the tribunal into substantive error. Contrast with, for example, Sahota, where although the tribunal's analysis was pretty high level, you really couldn't see on the face of it how Qureshi had been applied. The appellate court agreed the reasoning was sound, and so no further Qureshi explanation was required. And then last case on this we have is Talbot and Costain, and that was another case in which the claimant had pleaded a series of discriminatory acts, this time sex discrimination. She'd been unsuccessful below, and in her appeal, she pleaded a failure to stand back and look at the totality of relevant circumstances. Her appeal succeeded.
Tab 21. Yeah.
Yes, 21. So the appeal succeeded with the orthodox interpretation of Qureshi applied, and you can see that at page 380 to 181 at paragraph 28. I think Ms. Robinson is right to say that in deciding whether there was discrimination in relation to any particular allegation, the tribunal fell into error of looking at the evidence in isolation. But again, if we look at the kinds of criticisms the EAT made of the tribunal judgment, we can see that again the EAT had objections to the substantive reasoning of the EAT, and that's what's fueling this finding. So you can see examples at page 376 at paragraph 17. In the middle of the paragraph, the EAT was concerned that the tribunal failed to form views about the witnesses overall. And at the end of the paragraph, it was said that the tribunal appeared to be forgetting the potential significance of the documents not recording things or not being produced by the party in possession of them. And over the page at 379, at paragraphs 21 to 2, the claimant had made important allegation about a sexist comment, and the tribunal had kind of backed away from it, saying all there was conflicting evidence and it couldn't decide if the comment was made. And at 22, the EAT criticised this for not taking into account the overall picture, trying to assess the two witnesses as witnesses. And really we can see the EAT had become concerned about the Qureshi duty because it had real concerns about how the tribunal was weighing evidence, using evidence. It wasn't about a failure to draw on primary facts in their totality in order to draw inferences in the Qureshi sense at all. It was fundamental and substantive problems with the analysis.
Well, essentially, they'd abdicated their duty to find facts.
Yes.
Of the only woman who'd ever worked himself.
In circumstances where there were some negative factual findings, which are described at the end of paragraph 22,
Yes.
they found he was partly responsible for hostile work environment. He frequently openly loudly criticised her work, said it was a waste of time. She was building a document empire for her own financial gain. He refused to work with her on one occasion, lying about a missing bike.
Yes.
Yeah, okay.
So contrast that scenario with Sahota, Fraser, Coley, when the EAT feels that the substantive analysis of the tribunal of each allegation is fundamentally sound, so it doesn't need to see big signposting of Qureshi analysis in order to believe that the tribunal had the bigger picture in mind. That's all I have to say about that line of case law. So having established what the Qureshi duty is and what's required in order to show that the tribunal is applying it, this court will need to ask itself, did the Employment Tribunal apply it in this case? My submission is that it did. When considering whether or not the law was adequately applied, it's of course important to bear in mind the authorities which you'll be familiar with that urge caution when reviewing tribunal judgments. I've got two in my skeleton, Brent and Fuller, for the proposition that when there's been a correct self-direction in law, a tribunal decision should be read in the round, and the appellate court should avoid hypercritical and pernickety critiques. You needn't turn it up, but that's authorities bundle page 232 at paragraph 30. And along the same lines, DPP and Greenberg, that where a tribunal has correctly stated the legal principle, an appellate court should presume that the tribunal applied it unless the contrary is clear from the language of the decision. So with that in mind, I turn to the judgment subject to appeal, and we can see the following. So the tribunal cited Qureshi at its paragraph 151,
Page.
which is at page 117. And that self-direction is a very important starting point given the principles in Brent and Fuller and the presumption in DPP and Greenberg.
And Mr. Perry accepts it's correct.
And-
It's actually quite a full
It is.
direction.
It is, and that was what I was going to note. We can see that the tribunal didn't just blindly cut and paste a few words from Qureshi. It correctly analysed more than one authority here, or the principles from them, and their relevance to the case. So Employment Judge Quill said it's important not to carve up the allegations and only consider them one by one. That language is from Reed and Stedman. And then it's important to stand back and have regard to the entirety of the conduct which is found to have occurred. And it's actually the last line that's particularly insightful. Employment Judge Quill then said it's particularly important when considering whether it would be reasonable to have regard to the conduct as having the prohibited effect. That's Reed again. And whether to draw inferences that the conduct was related to the protected characteristic. That's Qureshi and Rial. Other than Reed, there's very few cases that make that point about the significance of the entirety of the conduct to the prohibited effect. But Employment Judge Quill is right that in a harassment case, that Reed point might be particularly important. An act might not have a harassing effect in isolation, but it might do when viewed in context. So Employment Judge Quill's approach to drawing together the principles from these authorities is actually a sign of a high level of engagement with the principles in the case law and their relevance to the case in front of him. The tribunal then undertook detailed analysis of the entire factual history. As indicated in Coley, it dealt with the facts in a single narrative at the beginning, before considering each of the allegations of discrimination, its context grouped together. And every time the tribunal considered an allegation, except for two, which we'll come to, it made the positive findings specific to that allegation, and then consciously stepped back for a Qureshi-type analysis, using this analysis of whether there were any facts that could lead to a finding of discrimination or harassment. That's the wording in Fraser. And it found in each case there were no facts that could lead to a finding of discrimination or harassment. And each time, its reasoning on its positive findings is sound. So I've given you some examples in my skeleton at paragraph 20. It's worth looking at them in the judgment. So if we turn to page 117 at paragraph 154, right, we're already on 117, so just down the page. At 154, the tribunal drew on its positive findings of fact that Mr. Young didn't deliberately give the claimant tasks to do with the intention of preventing her leaving to go to a hospital appointment. And he wasn't aware that she would not be able to go to the hospital appointment that day. She didn't tell him. It could have then made a narrow finding. It could have said, we find from these facts alone that he wouldn't have allocated any different tasks to her that day if her father didn't have cancer. And that might have given a bit more ammunition to this appeal. But it doesn't do that. At paragraph 155, it uses this stepping back language and says, there are no facts from which we could conclude that he would have allocated any different tasks to her that day if her father did not have cancer. And that wording, there are no facts, corresponds...
It uses the very same formula in relation to a slightly different aspect of that allegation.
Yes. Yes, it's a theme throughout the judgment. It's exactly the same wording that's used in Fraser. And it is a wording that we must assume is designed to comply with Qureshi. One, because it follows through Fraser. Two, because of the presumption in DPP and Greenwood that having set out the law properly, he's following it. And three, because we've seen just how carefully he has set out the law.
You said Greenwood. I think it's Greenberg, is it?
Oh, I'm sure you're right, my lord, yes.
It's Lord Justice Popwell.
Yes. Then at page 118, over the page, at 157, the same approach continues. Tribunal made the positive finding that in subjecting the claimant to disciplinary proceedings, Mr. Young, this is the last two sentences of paragraph 157, wasn't trumping up a false charge against the claimant. He was genuinely continuing with a course of action which he had embarked upon previously, i.e. before he knew about her father's disability. He had hoped the feedback would have been sufficient for the claimant to make steps to improve. However, in January, he decided that she was not improving. And then again, at paragraph 159, the tribunal uses that stepping back language. There are no facts from which we might conclude that he would have reached a different decision than to send his 29 January letter if the claimant's father was not disabled. At the bottom of page 18 at 162, the tribunal again made a positive finding about Mr. Young's reasons, finding that Mr. Young genuinely believed that the claimant had been performing poorly and a verbal warning was the appropriate outcome. And then over the page at 163, again, the tribunal steps back to survey all the facts for the Qureshi analysis, finding there are no facts from which we could conclude that Mr. Young would have made a different decision if her father did not have cancer. Also on page 119, at paragraph 167, the tribunal makes the positive finding that neither Mr. Rustall nor Miss Keeley were aware that the claimant's father had cancer. At paragraph 168, again it steps back. There are no facts from which we could conclude that any failures by them to provide information or respond to any email were related to the fact that he had cancer. Finally, the same approach is taken at the bottom of 120 and over to page 121, when the tribunal dealt with the allegations regarding the claimant being asked to go home after she was offered the settlement agreement. So specific positive findings are made on about the facts at paragraphs 180 to 182. And then at 183 and 184, tribunal zooms out for Qureshi and concludes there are no facts from which we could conclude that at 183, the claimant had been treated less favourably than an actual or hypothetical comparator, or at 184, that the conduct was related to her father's disability. The only allegations in respect of which the tribunal did not use this language are where the tribunal found that the act was so trivial that to call it harassment would cheapen the meaning of the statutory language. So those are the examples at paragraphs 172 and 178, which are on page 119 to 20. They both involve comments by Mr. Astill, Miss Keeley, who are the employees who didn't know that the claimant's father had cancer. It might be helpful here for me to respond to your question to my learned friend about what is required for an act of harassment to be related to protected characteristics. And from what I can see, related to imports a potentially very broad test, leaving the scope of the term largely to employment tribunals to apply on a case-by-case basis. There is now some authority suggesting that a mental element is required. In the Court of Appeal Authority of Unite the Union and NAILARD, 2018 IRLR 730. So the Employment Tribunal had allowed that a failure to address a sexual harassment complaint made against elected officials of the union made it against elected officials of the union could itself amount to harassment related to sex because of the background of harassment related to sex. And that, the Court of Appeal held, went too far. So the ET had not made any findings as to the mental processes of the employed officials of the union dealing with the complaint and whether they had been motivated by sex discrimination. The Court of Appeal noted that the previous potential liability for the third-party harassment under the Equality Act 2010 Section 40 had been repealed, and there was no automatic liability for the union. So absent that mental element, that there wasn't enough, the court considered, for the but for that there was in this case to amount to related to.
This case isn't in the bundle of authorities.
No, this case was my quick research in response to
Right.
your
So,
question.
sorry, could you give the neutral citation, please?
The neutral citation is 2018
Yeah.
EWCA Civ 1203.
Thank you very much.
Now, it's helpful, I would submit, when looking at those two paragraphs, 172 and 178 of the judgment, to consider the EAT's analysis of this decision below. So their analysis was that the Employment Tribunal hadn't lost sight of the whole picture, but that if there was any failure of the tribunal to show its workings on Qureshi, it was because the Qureshi analysis so obviously wouldn't have made any difference in this case. And you can see that in the judgment of the EAT at pages 77 to 8 of the appeal bundle.
Before you go on to that,
Yes.
do you want to say any more about this question that you addressed by reference to NAILARD as to whether the conduct here was related to disability?
Yes. Well, I think building on NAILARD, that is some suggestion in the case law that it wouldn't simply be sufficient for there to be a but-for relationship to disability if the person in their mind had no motivation that was related to the protected characteristic.
Well, in this case, the finding of the tribunal was that both it's Mr. Estelle and
Ms. Keeley.
Miss Yohal, I think,
Oh, yes, you're right. Ms. Yohal, Ms. Keeley and the other one.
didn't know about
That's right.
the appellant's father's position.
Yes,
So can't have been motivated
exactly
by
right.
any disability considerations at all.
Yes.
Well, I mean, are you taking the point that it really doesn't matter what the answer to the Qureshi point is because that in itself is an answer? It's not
So-
something you've said.
No, I think the way that I would put it is that the tribunal seems to have analysed it that it at the effect stage and said that it couldn't objectively have had a harassing effect in circumstances where the claimant knew that they didn't know and so they couldn't have been targeted comments.
Is that right?
So they say it cheapens the meaning of the that they are looking at the threshold of effect, because they are talking about cheapening the meaning of harassment, which is an expression which is from the case law on effect and triviality.
Yes, I mean it's quite clear that you need to have a number of elements before it's harassment.
Yes.
If one looks at section 26 as set out at paragraph 144, there needs to be conduct that's unwanted, and they said yes it was. Needs to be related to a relevant protected characteristic, and they say, well, there is a protected characteristic, so it doesn't need to be your own disability, but it can be your father's disability. And we will assume it's related. They don't decide it was, they say we'll assume it's related. And then it has to have either purpose or effect. And purpose is clearly looking at what's in the person who's doing the conduct, what's in their mind, but effect is not. Effect is the impact it has.
Mm-hmm.
And they decide the point on the effect, as you say. But I don't read in their decision on effect that part of the consideration is that the claimant knew that Mr. Astle and Miss Yohao were unaware of her father's disability.
No, I mean, I think the furthest they go on this point expressly is at paragraph 178, when, having analysed it in that way, they say whether it might have been different had Miss Joha had been aware of the true facts is a matter we do not need to address, because she wasn't aware of the true facts. And I think that's admitting to the obvious point that had Miss Johal knowingly made that comment, and had the claimant known that she known, that might well have changed the analysis of the effect, but that's not the territory we're in.
I read it as being, well, one might then be getting into purpose. If you know someone
Yes.
is late because their father's in hospital, then making a sarcastic remark might well be thought
Yes.
to fit into the purpose box rather than the effect box.
And I think there's just any number of ways why you can analyse why these acts weren't harassment, because they are so far from harassment. And that's why the tribunal has reached for this expression from the case law, cheapening the meaning of the statutory language.
Well, I understand that, but if I can go back to the question, the tribunal has clearly not rejected these complaints on the basis they're not related.
Mm.
But what I understood you to say from Unite the Union and NAILARD is that they could have done, and I just wondered whether that was a question we were being asked to consider, because it's certainly not in your...
No, I answered that question because it is a question that you had put to us. I'm not, on the basis of my brief research right now, in a position to be able to make a confident legal submission that that is the direction of all of the case law. So I give you that information to be of assistance, but not because I'm trying to make a new direction of submissions.
Thank you.
Turning back to what Taylor had to say about this in the AT, he said, we do not consider that the Employment Tribunal lost sight of the necessity. Sorry, this is pages 77 to 8 of the appeal bundle at paragraph 43.
And it's Judge Taylor.
Yes, Judge Taylor.
Even His Honour Judge Taylor.
Possibly even that.
What His Honour Judge Taylor had to say about this in the AT is, we do not consider that the Employment Tribunal lost sight of the necessity of an overall assessment in appropriate circumstances. It's not surprising that the Employment Tribunal said little about overall assessment, because there was little more on the facts of this case that an overall assessment could achieve. 3 incidents involved 3 different employees, 2 of whom didn't know that the claimant's father had cancer, all of which were relatively minor. The ET firmly concluded that harassment had been established in respect to the complaints, had not been established in respect to complaints. There was nothing more an overall assessment of the conduct could reasonably add that could result in a different determination. So my case, as you know, is that in fact the tribunal did signpost its compliance with Qureshi pretty clearly throughout most of the judgment. But in respect of these 2 acts, the alleged conduct so obviously wasn't harassment for so many different reasons that His Honour Judge Taylor is right that explaining the Qureshi analysis would have been obviously unnecessary. Because contrary to my learned friend's submission, these aren't borderline cases. These are findings that the allegation has fallen so far below the threshold that their failure has been remarked upon by the tribunal. It's wanted to use that extreme language of cheapening the meaning of the statute. These incidents involved nothing of practical consequence happening to the claimant. In each case, we saw that Mr. Young speaks to Mr. Hull about the comment and he doesn't act on Mr. Astle's report about the lateness. They're perpetrated by people who didn't know about her father's illness. The report about the lateness is factually true. Applying Sahota, there's no need to conduct any express Qureshi exercise when the positive factual analysis you can make here is determinative or fatal in and of itself. The tribunal had already found all the relevant background facts in its factual narrative per Coley. So what could it really have added here to expressly refer to other facts, which might have but hadn't changed the tribunal's clear rational findings? Taking a fair and holistic approach to reading this judgment, the EAT was right to conclude that the tribunal had the bigger picture in its mind throughout, including here. Those are my submissions on ground 1.
Do you want to address the specific point that Mr. Perry rested his case on, which is the effect on an individual when it's a second incident?
Yes. I don't think there's anything more to be said other than that it's only fair on the tribunal to assume that it had that in mind. It doesn't need to say that it is doing so expressly. So we have seen that it has found all of the primary facts. We have seen that it is put both of these incidents in the same section as each other, which is something that the EAT has praised. And it has made positive findings on each that are rational in and of themselves and are conclusive of the issue. It wouldn't have made any difference had the tribunal considered them expressly cumulatively. But given that it had self-directed that it should do so, we can assume that it did. We have no reason to assume that it did not, given that we can see, looking at it, that it wouldn't have made any difference. So that's an application of the point that I've just made to you, that taking a fair and holistic approach to reading it, we know that the tribunal had the bigger picture in mind. We know that it was engaged in Qureshi analysis, and we can assume that it applied that Qureshi analysis there, but that it wouldn't have made any difference.
I just want to check with my lord and my lady before you move to your next point. Right, thank you. Ground 2.
Thank you. So that brings us to ground 2, which is also about matters that the tribunal didn't express directly. And there were 2 matters that the tribunal recited when it set out the list of issues, but on which it did not expressly give reasons for its findings. And they're both arguments as to why the claimant said her dismissal was ordinarily unfair, whether the respondent had considered lesser sanctions, and whether the respondent had followed incremental disciplinary sanctions. I've cited for you Balfour, Beattie and Wilcox, in which the Court of Appeal explained what's required for the tribunal by way of reasons. At Authorities Bundle, page 143, at paragraph 24, the Court of Appeal referred to what is now Rule 62.5, which provides in relevant part, in the case of a judgment, the reasons shall identify the issues which the tribunal has determined, state the findings of fact made in relation to those issues, concisely identify the relevant law, and state how the law has been applied to those findings in order to decide the issues. And then at 25, the Court of Appeal stressed that this is a guiding principle, not a straitjacket. The question is whether these matters can be reasonably spelt out from the Employment Tribunal's judgment. That approach to reading judgments fairly and looking for what can reasonably spelled out, of course, reflects the authorities that I've already taken you to, and assuming that the tribunal will apply the law that it set out. I also have in the bundle Edwards and Everard, which at Authorities page 427 at paragraph 33 emphasise that the principles in Brent and Fuller should be applied to reading a judgment generally, and reflected the importance of reading Employment Tribunal judgments fairly and in their entirety. And over the page at paragraph 38, the EAT also explained that it will not always be necessary to address every legal issue. Providing clear and concise reasons involves focusing on the key issues and setting out the determinations in respect of them. It's helpful if a judgment sets out only the law relevant. Sometimes the answer to one of the questions that arise in the analysis of a statutory provision may mean it's not possible to give a full answer to other questions.
The point he makes in paragraph 39 is also perhaps relevant.
Yes.
Judgment reasons designed to show the outcome rather than the totality of the thought process of the
Exactly. And we know that in an unfair dismissal case, all of these questions, such as incremental sanctions and whether alternatives have been considered, they are all issues that may be relevant to the broad question of whether the dismissal was fair in the circumstances or within the band of reasonable responses. It so happened that in this case they were set out in detail in the list of issues, but in many cases they're not. In many cases you will only get that high level question set out in the list of issues.
I think I'm right in saying that His Honour Judge Taylor sat as an employment judge before he was made a circuit judge and started sitting in the EAT.
You have information there that I do not have. So my case here is that the determination of the two issues concerning lesser sanctions can be reasonably spelled out from the Employment Tribunal's judgment if it is fairly read as a whole. So first, as I said, the tribunal expressly identified these issues as it recited the list of issues. So that is in the appeal bundle at page 90, at paragraph 5.2. The first is actually at the bottom of 89. So we have failure by the respondent to give a warning to the claimant that she would be dismissed if her performance did not improve. And it is said that there was no consideration of sanctions less than dismissal. That's the self-direction. So we know the tribunal had those issues in its mind when deliberating and writing its judgment. And I should submit that by close analogy, we should also apply the principle that Lord Justice Popperwell gave us, that where a tribunal has correctly stated the legal principles, an appellate tribunal should be slow to conclude it didn't apply those principles. Well, here the tribunal has identified the relevant issues to be determined, and so we should be slow to conclude that it didn't determine those issues. Second, we know that the tribunal had heard evidence, cross-examination and submissions on both of these points. So in my skeleton argument at page 11, which is in the appeal bundle at page 18, at paragraph 26b, I've cited extracts from the respondent's closing argument, which in turn cited the witness statement. Both of these documents were before the EAT. Skeleton argument argued that the respondent had carefully considered alternative sanctions. Steve Young gave evidence about this at paragraph 80 of his witness statement. Marwan Bate gave evidence about it at paragraph 37 of his witness statement. And that there was no obligation to provide further warnings. That was the respondent's case. The respondent's non-contractual disciplinary policy was at bundle reference. It provides the situations in which warnings will usually be given, but does not require them to be given. And in the claimant's case, she had already received clear instructions as to how she must improve in 3 performance reviews and was given a warning before she was ultimately dismissed. This is ample to ensure that the dismissal was within the band of reasonable responses. I also, this morning, have been looking at the paragraph in my closing skeleton argument, which again was before the AT, which dealt with this question of why it was sufficient that she hadn't had a warning in respect of the refusal to change line managers. And this is what the tribunal had heard in closing submission on that. The claimant accepted in the May disciplinary meeting and repeated under cross-examination this week that she had been refusing to report to Mark Astle for years due to her feelings about a previous manager. The tribunal also saw Steve Young's witness evidence explaining the history of the claimant's refusal, paragraphs 8, 11, 12 and 14 of his witness statement, and emails from 2018 showing concerns being raised internally that her reporting line had to move to Mark Astle. It saw in the minutes of the May disciplinary meeting her repeated failure to give a positive answer to Mr. Young's question, can you work with Mark? Under cross-examination, the claimant was asked whether she knew how much longer it would have taken to finish the counselling that would have enabled her to work with Mark Astle. She still didn't not answer the question and again began talking about her historic trauma. Marwan Bate, who conducted the appeal, further considered the line management issue. So that was what was in front of the tribunal on why she didn't need to have been given a further warning in respect of the line management issue. With all that evidence in front of it, the tribunal made all the relevant factual findings. So it recorded analysis about the escalation of negative performance reviews and sanctions for performance. I've given you the references. Would you like me to take you through the references for the performance? Then I won't. And the tribunal then engaged carefully with the reasoning adopted by the respondent explaining the dismissal. So then at page 109, at paragraphs 106 to 7, it accepted that the outcome letter contained Mr. Young's genuine beliefs. It identified the refusal to accept new reporting lines as the main reason for the dismissal and analysed Mr. Young's reasoning in the dismissal letter as to why he believed the claimant would not change her position on this. You can see that further at pages 110 to 11 at paragraph 110.
Yep.
And we can see further analysis of that at page 122 at paragraphs 195 to 6. And then finally, over the page, at page 123, we can see at paragraph 201, consideration of whether the dismissal was within the band of reasonable responses, which is the legal issue to be decided. And we can see that in the last sentence, the tribunal relied on the fact that the claimant was making it clear that she would not be willing to start reporting to Mr. Astle in the immediate future if she came back to work. And that is directly relevant to whether there was any alternative to dismissal and whether going through lesser sanctions first would make any difference. And finally, the tribunal concluded that some reasonable employers would have dismissed in the circumstances. My submission is that given the issues that the tribunal had identified, given the evidence and submissions it had heard, given its own analysis of the facts, it's fanciful to imagine that the tribunal wouldn't have considered whether a lesser sanction should have been adopted or whether the dismissal was fair in light of the extent to which the respondent had considered lesser sanctions. That's what this case really was about. Was it fair to dismiss this woman in circumstances where really they've been talking about performance for quite a long time, and they only became focused on the line management issue in a very documented way in 2018. That's what most of the week had been devoted to. They make careful factual findings on what happened and how in the meeting she'd repeatedly not been able to answer the question, are you willing to work with Mark? And concluded in the circumstances it was fair enough to let her go. So those are my submissions, save to comment on disposal. I've set out for you at paragraph 41 of my skeleton argument the relevant principles from Sinclair Roche on whether, if you uphold elements of the appeal, this case should be remitted to a different tribunal. I make my submissions to you against a backdrop of the rather sorry tale of the progress of this litigation. As you've seen in the judgment, the facts of this case arose between 2015 and 2018.
No, we have the dates.
The upshot of this is that if this case were to be heard again, it would likely be on current listings, I understand, sometime in 2016, more than a decade after the facts in dispute. So there are very real questions. 2026, more than 10 years after the facts in dispute. So there are very real questions about whether there could be a fair hearing at all at this point. My submissions in these circumstances are that it would be wholly disproportionate to send this claim right back to square one with a new tribunal. I set out the points more fully in my skeleton argument, and I won't deal with them at any length. But in short, they are that this was never a very high value claim. The claimant's annual salary was £42,000. She has no other losses beyond injury to feelings, and far more than that has already been spent on these proceedings. The passage of time tends strongly in favour of remitting to the same tribunal. While some time will have passed since the tribunal panel heard the case, the tribunal recorded such detailed findings of facts that it should have no difficulty in reconsidering discrete points raised in this appeal. By contrast, we cannot sensibly ask these witnesses to summon up their memories of 2015 to 18 again at a hearing in 2026. There's no allegation of bias or partiality here to suggest that a different panel is required. And even taking these grounds of appeal at their highest, there's no suggestion that the first hearing was wholly flawed or completely mishandled so as to require a different panel. There's nothing to suggest that the tribunal wouldn't be willing or able to reconsider any discrete points. And of course, you're required to take into account the professionalism of the tribunal when being asked to conduct this sort of task. Those are my submissions, unless I can assist you further.
Thank you.
Thank you.
Mr. Perry.
I'm not sure there's anything particularly that I need to respond to. My lady, save to acknowledge that Nailard, United Nailard, is quite possibly relevant to the question of whether the tribunal's finding on that the two incidents in question were related to disability. I acknowledge that that's relevant authority. But other than that, I think.
Right, Mr. Perry Misharks, thanks very much indeed for the assistance which you've given to the court this morning. We are reserving judgment in the usual way. The draft judgments will be handed down electronically, but in advance of that, the drafts will be sent to the parties for correction of typos, corrections of only typos, and you'll be requested to draft an order. If it can't be agreed, then limited written submissions, please, as to the final order to be made in this matter. I know you will have submitted the names of those to whom this draft should be circulated. If it requires to be circulated to anyone else, please request to the court. And the consequences of breaching any of those rules, in particular the embargo on the draft, are set out in the Counsel General for Wales case. Thank you both very much indeed.
All rise in favour.
Thanks very much indeed.
Just to make the court aware, the live stream is still running for another minute.
Thank you. We were done by lunch.